Hello everyone, my name is Lauro Parenti, I'm from the Arbitration channel, and we're going to discuss today technology in arbitration. I have the honor to have here with me Karima Sauma, is the Executive Director of Center of Conciliation and Arbitration of American Chamber of Commerce in Costa Rica. She's also a professor in two universities in San Jose and counsel at DJ Arbitraje. So also leads the Costa Rica chapter of Legal Hackers. Tomás Navarro, Blake Moore, is a dual qualified lawyer in Spain and Switzerland with LLM International Dispute Resolution from the Graduate Institute of Geneva. Tomás worked as a consultant for an NGO in Cambodia, rule of law, and access to justice matters before joining Swiss law firm Froriep in Geneva, where he principally works with international and commercial arbitration and sports arbitration, governance, and fundraising. And to be our host here and organize the discussions, we invite Mauricio Duarte. He's a lawyer from Guatemala with LLM in US. Mauricio worked in international arbitration before devoting himself to issue related technology and legal innovation. Mauricio is the COO at A2G Tech in Denver, Colorado. Mauricio is one of the hosts of Legal Hackers podcasts in Spanish. So thank you for being here with me. And good morning, Mauricio. And please.
Good morning, Lauro, and good morning, everyone. And I know we're at different time zones. In fact, earlier in the morning, we were discussing if we were at the right time because of daylight saving. But I just want to thank again to the arbitration channel, to Lauro and everyone else that has been involved in making this discussion. And just to lay some ground rules and how this discussion will work, is going to be a very informal discussion. It would be more of a dialogue between two good colleagues or good friends that I met when I was in arbitration, but now, even though I'm in technology, they still have some relationship with me. So I'm happy to be on this discussion with two good friends that I know that understand many caveats of technology. So it's going to be a compelling discussion. But before starting, I always want to make an introduction on the relationship between arbitration and technology. We're not going to go into detail, and we're going to explore even more as we bring some discussion points. But I used to be in arbitration. I used to work in commercial arbitration, not necessarily in investment arbitration. But there was always a part of myself that thought technology could leverage and improve international arbitration. Although international arbitration has a lot of benefits that probably Karima and Tomás are more experts at this moment than I am on the benefits of arbitration. Any process, regardless if it's litigation, arbitration, mediation, can always be improved, and technology can leverage the efficiency of those processes. So when I was noticing that, I started to shifting my focus on technology. I still have a passion for arbitration, but I'm not a practitioner anymore. But I'll say that everything started to show with the COVID-19 pandemic, in which we saw the need to embrace technology, use it wisely, and start understanding how it relates to any part of the legal industry, in specific with international arbitration. And we're gonna hear the perspective from Tomás as an attorney and a practitioner, and Karima, that is the head of an arbitration center, and that is gonna give us compelling perspectives about the use of technology. But the thing that I came to a conclusion last year, and still, although the pandemic is still ongoing, but hopefully we're seeing the end of the tunnel, is that technology can be used for good purposes, but before using technology, we gotta understand some of its components. It's not necessarily good to just talk about technology without knowing some of the technical aspects that go into it. It doesn't mean that you have to be an expert, but in order to implement and use technology wisely, you got to have more discussions about what technologies can be really used, what technologies are we there yet, and which technologies could be down the road, but not necessarily on that path right now. So, for instance, just an example, sometimes we talk about artificial intelligence, smart contracts, blockchain technologies, augmented reality, which are good technologies, which are probably gonna be prime for disruption in the legal industry. But now the question is, are we really there yet? Or should we embrace other type of technologies before moving on to other complex technologies? So with that, I will like to welcome Tomás and Karima, that as Lauro has already introduced themselves. Tomás is a practitioner. He's mainly focused on Europe, on arbitrations, but he has vast experience in international arbitrations. And Karima is the head of an arbitration center in Costa Rica. So to get started, and again, thank you, Karima and Tomás, for being with us today. I want to start probably this discussion with some of the items in my introduction and we can start with you, Karima, is from your perspective, do you think arbitration has been what they call late to the party in embracing technologies or embracing more technologies? How do you envision that approach, or that sometimes it could be a false premise or a misunderstanding?
Thank you, Mauricio. Thank you, Laura. First, I just want to say good morning to everybody, and thank you for having me here. It is such a pleasure to be speaking with two great colleagues about these topics that are just so timely given COVID. As to your question, Mauricio, lawyers are late to the game in general, just because we're so traditional, and people like to point out that we are and our profession in general is something that has made us very traditional and very wary of innovation and of trying new things. And so, and not only regarding to technology, but regarding to other things, how we dress, how we, we all know this, and I must say I like the traditional aspect of our profession, but this has made us late to the game in many aspects, and technology has definitely been one of them. In international arbitration, because of the flexibility components, and because it is something that has been separate from, for example, the judicial aspect, which has to be linked to states, or other types of the law that has to deal with other more bureaucratic aspects, I think did have a more technological aspect than other areas of the law. But then came COVID, and we saw that, oh wow, we did had come a long way, but we still had a long way to go in other aspects. So in short, I sometimes feel that because there is so much technology around us, people like to think that we're definitely left behind, but I do not think that's the case. If we compare arbitration to other areas of the law, I think we've definitely gone to great lengths, and you can have an arbitration process pretty much online and with different technology tools. It depends on what type of technology we're talking about. And I think that's where the question becomes more complex. Are we using more complicated tools? Are we using some of the type of tools that you were talking about that maybe are not here? And how far are we along compared to other areas, not of the law, but of other industries and other sectors?
And I like that approach in the sense that we are traditional in some sense. I still like some traditional aspects of the legal profession, although I'm more in technology. I don't wear a tie, that I must admit, but I still wear a formal shirt from time to time. So, Tomás, now with that take from Karima, what is your perspective on how arbitration reacted, how did we embrace technology, and how have we, the industry of legal of international arbitration has embraced technology. Do you still think that we were late to the party? We were pioneers during COVID. What is your take with the approach on that synergy between technology and arbitration?
Thank you, Mauricio. It's great to be here to share this panel with you, with Karima. And thank you, obviously, to Lauro and all the arbitration channel team to host us today. I think there's no better topic to talk about it. And actually, it's quite a first for me to do this live on YouTube, being in the background here. So it's right on time. I did have some issues with the internet in the firm before, and I said I can't have issues talking about technology here. So thank God everything is working well. And I did smile when Karima, and of course when Mauricio also mentioned that the way we are traditional, and this is true in the sense that we'll come to this probably in what have been perhaps some of the challenges for us to embrace technology more than what should have been. The traditional aspect is true. I was even thinking this morning, should I wear a tie or should I not wear a tie? And I didn't. I think if we see the way we are today talking is a show of how we are. But in thinking when Karima was answering her question, and also obviously preparing for this conversation, I did go through obviously some conversations, some articles, and actually one of them, which was a book which was titled "The Evolution and Future of International Arbitration." Well, okay, it's dated 2016, but it did say international arbitration has failed to embrace technology. So, of course, as I said, we're talking about 2016. We're in 2021, COVID in the middle. We have, as Karima mentioned, we've done a huge leap forward in terms of, well, obviously we'll go into more details, but virtual hearings. But yes, there is this traditional aspect of not only international arbitration, but the dispute resolution aspect of the law. We are, in a way, we are focused on the human side of it, and this is also when I thought about this, it reminds me of this book which all of you recommend to read, is Talking to Strangers from Malcolm Gladwell, where he also make some comparisons between judge and algorithm. Well, again, this is something we can discuss further on, but there's an interesting passage of it where he quotes a judge, and a judge had someone in front of him to testify, and had a mask or something, and the judge said, and I quote, "One of the things that I need to do as I'm listening to testimony is I need to see your face and I need to see what's going on." And then I continue, and I can't see certain things about your demeanor and temperament that I need to see in a court of law. So this is just to show the mindset of especially dispute resolution lawyers or the dispute resolution field, is that we are still very much focused on the human side and how important it is to see, to feel, to be in a room. This obviously has been, as I said before, we've had a leap, and this has been gone forward with the COVID. So yes, we have been, I believe, late, and I see it also in my practice now. I feel sometimes I'm short-handed in some aspects of the procedure where I would say I could have a technological tool which would help me enhance and be much more efficient. But I think this has made us move forward in a way that there's no going back. And now is the time, especially us that are in the midst of the cases, in the ground, doing the groundwork, is really to push and say, look, there are these technologies, there are these document review programs that we can use, there is these virtual hearings settings that we can use, there's these presentations that I was looking at some of them and they are incredible. So we are going there, there's work to be done, and technology international arbitration has, just in a way, as I say, followed the dispute resolution setting.
Karima, you wanted to add something on that? You're muted.
Oh, I'm muted? I'm muted? Can you hear me?
Yep, go ahead.
Okay. I just wanted to follow up on Tomás's point about how we're human-centered and feeling-centered, because I think that's precisely the most interesting aspect of all of this, and about the push and pull with technology, and especially why it's not something that we would want to see us dominate. And so what I'm thinking is, and what I wanted to ask Tomás is, was your comment, were you thinking, do you want it to be less related to feelings and to human-centered, or would you want it to be more so just for sake of the discussion?
No, great, thank you. Yes, I think the background of my comment on the human feeling, and this is something that both of us have discussed in our respective articles, which perhaps Mauricio will mention at the end, about whether, how, and if judges or arbitrators can be robots, or robots can replace arbitrators and judges. I think obviously the essence of the dispute resolution and knowing the parties, or seeing lawyers, will obviously remain human. There's a sense of fairness, of justice, of compassion that is has been said that is obviously necessary. But I had this in mind when I say that I did feel that, and I've seen that in the practice from counterparties, from arbitrators, from in the firm, saying that they would be reluctant to use technology, in the sense having fully virtual hearings, which for me, I've seen in the practice has worked wonderfully, unless there are any IT minor issues. They felt that no, they needed to be in the room. They needed to see the witness. They want to feel how the arbitrator is reacting. And to be honest, this is fully possible on a virtual hearing. So the human element, as I say, the basis has to be there, obviously, in terms of how do we adjudicate the dispute. But in terms of the different processes, this human element is sometimes overrated when we have technological tools which can replicate, or sometimes even better. I mean, depending on how you see me, you can probably see me better, the way I open my eyes, the way I react, the way I'm moving. So this is where I wanted to hinge on this human element.
I would say you bring up a controversial point, and I know Karima wanted to add some of this, so I will let her speak. But I just wanted to make a caveat on this, and is, from my perspective, and now that I'm not on international arbitration, I'm more on the providing side of technology, I do think that one of the criticisms that we can do to technology, and this is to any type of technology that we might use, sometimes we think that just putting a technology over something is going to make things better and it's going to improve something, which is a false premise. We always, at least from a legal technology perspective, we always have to find the pain points. What are the real issues on efficiency, how a process is working, and after assessing if it's needed or not, then you can add a technology. But it's not only just saying, let's add this technology, because there's a struggle. And I think Tomás and Karima mentioned it, is that every time that you implement a type of technology, it has to be centered around the user of that particular industry, of that particular need. If you just use any type of technology just to cover up something, it's going to generate even more problems. So I would say, even though the human element in arbitration, like Tomás said, sometimes could be overrated, I still think that technologies also have to make an effort to breach that gap and creating more solutions that are focused and customized to a specific type of industry or a specific type of customers. Because again, you cannot use necessarily, and I'm just gonna throw out an example. We have a tool for project management that I use quite a lot. For instance, I cannot use that on arbitration. Why? Because necessarily is not the best tool for that type of process. However, what if we had a legal project management tool with an arbitration, let's say, type of practice? Then you could have a more suited tool that is focused around those users on that industry based on that need. But Karima, you wanted to add something based on Tomás' discussion, so I want to let you speak as well on that issue.
No, I just wanted to say that it's interesting what Tomás was saying about virtual hearings, but I didn't want to get ahead of your questions, so I will let you. I will address that when you address virtual hearings.
Okay, sounds good. So with that, I think this discussion gives me a good transition to my next point, and again, point of discussion. But and we can start with you, Tomás, because I know you're more of a practitioner rather than, and then I can go to Karima. Is what have been some of the, let's say, struggles, concerns, or problems that you have noticed in embracing more technologies, at least from your perspective? Why, besides the human element that we were talking about, or that sometimes in your practice or judges could be hesitant about the human component, what are some of the other challenges, concerns, or struggles to embrace more technology from your perspective?
Thank you, Mauricio. Yes, that's a good point. It's true that there's a range of different, let's say, obstacles that permit us to, again, make this further leap or make this big leap into technology. And it goes back a bit to the point to say that there's technology, there's the human side, and then the technology has to match the user, and that's key, because obviously an arbitrator is not perhaps that tech savvy, or the lawyer is not that tech savvy, and the two parties, and it has to be a ground floor where it's a ground leveling floor for everybody. And this is one of, when you coming back to the point of some of the that Karima has already evoked at the beginning, our traditional way of working, the way that lawyers have traditionally for centuries worked, it has been ingrained in the profession. And one of the aspect is this, we are, let's say, highly risk averse. I mean, just think about a letter, or whenever I receive a request from a client requesting me for legal opinion on a certain matter, the amount, obviously, of diligence and research I have to do, but also the amount of caveats I have to say, because this has not been decided, might be repealed by the Supreme Court in Switzerland, there's a doctrine that says the other way. We move in an area which is difficult, especially in terms of our responsibility towards the clients, who obviously require us to provide the best services, and us to make sure that we don't fall in any of the any big mistakes. So highly risk averse, that has been what has characterized us, and perhaps this will change. Of course, one of the things is, and that's perhaps more general, is the fear of the unknown. I had a provider of document review program coming to the firm, and we went through the whole explanation. We did a demonstration, and obviously it was not me, it was with also some of the partners, and obviously everything was unknown. It's a bit complicated to get all the information and say, okay, we're going to go forward or not. Obviously that then depends on if it's that necessary for the firm or not. But this unknown, we're going into an unknown software where we don't know where the information is going to come, if we're going to be able to manage it. Then perhaps two other aspects that are, let's say, are going to be a benefit, but also have been an obstacle, is obviously time and money. Time, why I say, because sometimes we're so engulfed and so focused in our cases and in our work that we don't take the time that we need to invest in being more tech savvy, being more fluent in this technology. Money, because some of these software require money. Depends how much. Obviously, there's a whole range. And one of the aspects also that I have in mind is the concerns of security, because the aspect of confidentiality, and in particular the attorney-client privilege, is so fundamental to our profession. We face a risk, obviously, of having the data, of using some software which can be hacked. And I recall one of the cases which Portugal's largest firm was hacked regarding a confidential investigation regarding corruption charges of a big football club, and all these documents that the law firm was managing were made public. So that's just a very concrete example how this kind of issues can arise. And then there's an aspect also of our profession, is because we are there are certain regulations of the way we work. There are really protective regulations of our work, and I just can think of one example, and then I'll leave it to Karima or to Mauricio for some follow-up. There was an attempt here to do kind of a co-working space in Switzerland for different lawyers, using offices and different lawyers coming during different times of the day, and that went up to the Federal Supreme Court in Switzerland, saying that the way it was done, it was not possible, but it could be possible if strict regulation, a strict separability between the different lawyers, to make sure they would be independent, that there would no information exchange. So that just show that we are heavily regulated, and we have also these regulations to bear in mind. I don't know if that leads to some question.
It does, and with that, I think there's some things that you mentioned that I'm completely in agreement with, and I would say one of the biggest concerns, at least from my perspective, that I've seen from practitioners embracing technology, sometimes cybersecurity, but at the same time, and this I will let Karima speak as well, is lack of knowledge, as you said, no time, sometimes no allocation of resources to learn about certain measures or certain technical components. Because in my experience, sometimes people ask cybersecurity the problems, but when we go in depth, for instance, what is the protocol that we use in, if we mention something as technical as SHA-256, they were like, what is that? So there is some education as well that sometimes leads to that concern. Is with some education or with some, let's say, prior research, you can, let's say, put an end to those type of concerns. But I do agree that cybersecurity in general is one of the biggest concerns for practitioners. But at least, Karima, from your perspective, I noticed that Tomás mentioned money, time, security, and other issues related to what are the main concerns or challenges or struggles to embrace more technologies in international arbitration. But from your perspective, that you are head of arbitration center in Costa Rica, what could be those challenges that I think could be from a different perspective, and some of you could have some additional concerns, struggles, or challenges to embrace more technology?
Thank you. I do agree with the ones that Tomás mentioned. I do agree that cost is always a big one, whether you're counsel or an arbitration center or an arbitrator, or cost is always, and economic considerations always come to mind. But also, and with the traditional aspect, I would also like to include the age gap that's present in international arbitration. And so when you're dealing with arbitrators, as you see, and we've all seen the statistics, many of the international arbitrators are mostly older people who may not have as much experience with technology, and so may have a harder time adjusting to these processes. And so, as you say, education is definitely a huge part of it, but sometimes it's not enough. Sometimes they just do not want to incorporate this to their way of working. In general, I have seen parties very open and to working with technology, and I'm not sure if this is something that really depends. And it would be great if we had a study, a geographical study, because I've spoken with other, and we've had now in COVID, because of the change that we have from having everything and physical to virtual. We've had many meetings with heads of different arbitral institutions, and we've had many different experiences. And so, for example, CICAO, where I work, we had a great, people have been really receptive to having virtual hearings. We had files were all done electronically. Documents were all filed electronically. In general, things were pretty much going hand in hand with technological tools. But when I've spoken to my peers, this has really not been the case. And we've also had to manage cases from other arbitral institutions that do not have any of these tools, but are bigger than our centers, and that the parties need to find like a case management platform and a virtual hearing platform. And so we offer those services as well. And for me, it has been really interesting because our experience was that it was very easy. So the challenges were mostly in the economic side, or also getting the parties to trust about the confidentiality aspects of this, especially when you were having hearings with witnesses that weren't in the premises. So, for example, having witnesses that wouldn't have one of the opposing counsels in the same room would sometimes make the other side wary, because they wouldn't be able to see if somebody was coaching the witness or if somebody was influencing the witness at some point. But all of that was surmounted, and we were able to have normal hearings. And throughout the whole COVID, we were able to have virtual hearings without a problem. So I think these are all problems that can be overcome if the parties want to do it. And I think it is something with the culture of the parties involved.
Go ahead, Tomás. You wanted to add something on this question?
Yeah, this is. I just wanted a quick follow-up, but this is perhaps even for both of you, for both Karima and Mauricio, because Mauricio, I understand you provide the technology. When talking about the obstacles, Karima, and you said that you put in place, obviously, the virtual rooms, the data, the case management platform. What was in a way the investment? Was investment really important? Did you? I'm not talking. We don't need to have the figures here, but was it really a step that you had to make a huge effort to reach these capacities? And in that way, that's also a question for you, Mauricio. How do we need? I mean, obviously, it depends on what do we need, what if institutions or lawyers, but do we have to fear that there's a huge investment that needs to be done? Because you also mentioned, Karim, that was in a way easy. You saw this transition was feasible, easy.
Do you want to go ahead, Karima, and I can go last?
Sure, thank you. No, it wasn't a very. It was relatively easy because there are very economic tools out there that help with this matter now. Since it's something that, I mean, you have almost, well, we all know that for virtual hearings, it's very easy because we all have platforms where we can have video conferences relatively easily. So you just have to have an account, and well, you pay the license for the account, but it's not a very expensive license. And for case management as well. So it's a good investment for it. What's expensive is when you have more complex technology, and so that's another topic. But for this, for the basics, and I think that's where technology really shines, where arbitration really shines, because COVID hit, and you had many countries that didn't offer judicial services for many months because the government shut down because of the pandemic, because they didn't open government offices. And with arbitration, we didn't have to. For example, we never suspended any cases. And so, and when speaking with my peers, that wasn't the case everywhere. And I found that interesting because I think that with technology and arbitration is a perfect match because of the flexibility and the autonomy that this gives us, and just allows us to offer a service like none other.
I would say from my perspective as now a provider but previous practitioner, I would say there's sometimes this honesty in some of the technology industry, and I must be honest that sometimes we sell the idea of to be technologically savvy or to be perfect, you have to have complex products starting from scratch. But no, to be honest, as Karima mentioned, you can do very meaningful products that are suited based on some integrations with tools that already exist. For instance, I never knew this before, as an attorney, but you can create so many products and so many solutions with just understanding how to integrate one platform with another platform. And again, you just have to pay for the licenses of those products, but you don't have to start from scratch. Many people think that incorporating technology means building something and coding something from scratch. But actually, as we move forward, and there is a tendency in the legal technology market of using what is called no-code or low-code tools. That means that you don't necessarily need to code. You don't necessarily need to understand the capabilities and the functionalities of that tool, and then you can integrate. There are going to be some instances in which there are going to be some customizations needed for, let's say, a specific type of arbitration or for a specific institution, and that is probably going to drive a bit the price higher. But overall, you can have a functional solution with some basic integrations that is not going to be as expensive. In my experience, you can have a functional prototype, or what we call a minimal viable product for case management systems, for instance, for less than $10,000. And sometimes people said, really, is that possible? And it is. If you understand some of the other tools that are on the market, some of the integrations that can be made, it doesn't have to be this expensive investment of hundreds of thousands of dollars, but it could be even lower than that. But with that, I want to probably move to a different question, and with that, I invite everyone on the audience. If you're hearing us, I see that people from Brazil, from Turkey, from Texas, so everyone that is hearing, you're welcome to add questions or to ask, and we're gonna make sure to address them in this discussion. But I want to move to, now that we talked about more of the critical aspects of technology, from your perspective, and we can probably start with you, Karim, on this one. what are some of the benefits that you envision? And when I say benefits, are the practical or tangible benefits of using technology for the arbitration industry? Although we understand that arbitration has its own process, has its own regulations, its own international, let's say, instruments that sometimes give guidelines on arbitration. What are some of those benefits that we could see if we have a trend to embracing more technology? With the caveats that we mentioned, that there is need for more education, more human-centered tools, and other of the topics that we have addressed.
Well, the first definitely has to do with the one that I mentioned before, and has to do with just having arbitration be this process that's very flexible, that adapts to the parties, that can happen whether you are in different countries or different states, and that becomes a lot cheaper than what it is now. So technology is not only something that brings parties together, but at the same time, it's something that lowers costs. And lowering costs is something that users have always said that is one of their priorities to favor an arbitration. At the same time, I see technology as something that could help arbitrators, and in the sense of freeing them up from repetitive tasks, so that arbitrations become shorter, because they if we have tools for document processing, for document production, transcripts, case management, tools that analyze facts, that help them for analyze also case law, statutes, and all of that, that frees them to really focus on what's important. And this could also make the arbitrations go quicker, which is something that helps with the decision-making process, and also helps at the end the parties. It also we also get to see, and these are more complex tools, but at the same time, there are tools for counsel, for the parties to review briefs, process case and commentary as well, doc review, calculate costs, even result prediction. And so I see technology and arbitration as a symbiotic relationship, but I don't see it as something that many authors have described as an Armageddon scenario where technology is going to eat up arbitrators, and it's going to be the end of everybody's work, including yours and mine. I see it more of a symbiotic relationship where we're going to get to focus in the interesting tasks, in really what takes up thinking and emotions, and what humans do, and being freed up from everything that's repetitive, and just having more dynamic and quicker and more economic processes.
And Tomás, what are some additional benefits that you could think of, if any, while embracing more technology? I am thinking of one, and just to give you the word is, for me, and probably the most important one is, as technology embraces more technologies, they will understand and be able to tackle a new industry that is on the rise, and that is a more distributive and collaborative economy. That means many of the transactions are now online. You go to Amazon, you go to eBay, they have their own dispute resolutions, but many of the, say, more lower amount claims that are on digital transactions on every day, sometimes consumers don't have necessarily a remedy. So maybe we can see that also arbitration in some instances, I don't think is there yet because of the cost associated. But if we can lower those costs, as Karima was saying, maybe there is a new avenue for international arbitration to thrive on an industry that is more focused on end clients rather than just focusing on big businesses or big corporations or investors against states. Maybe we can envision a future in which arbitration is going to be suited with ODR mechanisms or other technology platforms to address and solve disputes. So that is for me the biggest benefit. But I want to hear you, Tomas, if you, from your perspective, see other potential benefits with this symbiotic relationship that Karima was mentioning between technology and arbitration.
Yes, but I really like what you mentioned, and actually, it really follows well where you work. If I'm not wrong, A2G is access to justice, basically, providing access to justice, and that was exactly also on a different level. Was working in Cambodia in terms of providing dispute resolution, more in terms of mediation negotiation for neighboring disputes, small family disputes to the population, because there was issues within the national court system, and that's in terms of obviously corruption, administration, backlog of cases, and that's exactly where I can see that technology for people who don't have necessarily the means or don't have necessarily the time or especially the means to have access to justice. I mean, it's just fundamental for the rule of law of our societies. And on top of what Karima has already mentioned, which is obviously key on the institution side and the arbitrator side in terms of time and money, this is obviously also the case for practitioners, for lawyers. When we talk about money, if we have a document review software that can go through all the case law in a split second, instead of having an associate or two interns going through it easily, well, obviously that's time and money for the client. And this is also something very important, both of you mentioned, in terms of focusing on what is important. And this is also, I remember this is what you discussed, Mauricio, in one of your Legal Hackers podcasts, where you mentioned that in terms of preparing documents, lawyers can then focus on the legal strategy, on the technical strategy that needs to be done, to put in place, and discussing with the experts of how to move forward with the case. So time, money, and I see other two aspects that I find interesting is making arbitration at least more diverse, making it more diverse in terms of having a wider pool of arbitrators, of practitioners, because let's face it, arbitration now less, but historically and traditionally has been centered around North America, Europe, and obviously now it's changing, and thank God, and it has to expand. And I'm talking about lawyers, and I'm talking about arbitrators. So this provides tools for someone sitting in Nairobi, can do his arbitration, be sitting as an arbitrator without having to travel, or in Lima, and another arbitrator in London, or again, we're talking about Singapore, lawyers in Singapore. So this diverse pool is fantastic in terms of also clients not necessarily needing to go, oh, I need to go to Paris to the big law firms to do international arbitration. No, I can do it in Santiago de Chile, or I can do it in Kuala Lumpur. There's no issue about that. And then an interesting aspect, and of course that's also followed the trend that we are in, is making arbitration greener. As you're probably aware, there's this campaign for green arbitration, spearheaded by Lucy Greenwood, where it's kind of a pledge where if we use more technology, obviously we will have more greener arbitration, in terms less flying, less paper, e-filings, and all this is obviously good for us and for the planet. So these are these two additional aspects that I thought about that are interesting and that we have to bear in mind in terms of technology.
Great, thank you for that. And with that, there is a funny point. And next week we're gonna have a discussion on the International American Law Society, in which we're going to address that relationship of technology and sustainable development of the legal industry. And I think Marcus Burham, that he's a professor in Europe, he actually brought up that point. How can we use technology to make arbitration and any legal practice sustainable and friendly to the environment? So that is a good point, and I'm glad that you mentioned it, Tomás. But with that, now I think we are entering, I would say, the final stage of discussions. And again, this is an invitation for the audience to ask any questions that you might have, and we can discuss it or address them on this panel. But just focusing more on the practical aspects of arbitration. And probably I can go back to my classes on arbitration, or when I was a moot court participant back in the day, or sometimes I think we met with Tomás in a couple of moot courts as arbitrators back in a couple of years ago now. But usually you hear the phases of the arbitration process. So normally you start with the arbitration clause, that needs a negotiation. After you have the arbitration clause, then you go to the appointment of arbitrators, then you go through the evidence process until getting the final award. And there are many, let's say, details to every facet of the arbitration process. And with that, at least from your perspective, and I would like to start with you, Tomás, on this one, is what are a phase or a specific item on the arbitration process that could really benefit from arbitration? Is it the execution of arbitration agreements online? Is it the exchange of evidence? What would you say is what we call the low-hanging fruit of disrupting that facet of the arbitration process with using simple technologies that don't require complex technologies?
Sure. Yes, I like the fact that you mentioned your education, because that was a point I wanted to mention about our education in international arbitration. As I mentioned, as Laura mentioned, I did an LLM in dispute settlement, and I was curious about that, and I checked the different. Now there's a lot of different LLM programs or masters in international arbitration. If they provided courses on technology or the use of technology, and I didn't find a lot. Of course, I didn't do an exhaustive research. I only saw one in the Paris Assas LLM, where they have a course on artificial intelligence in the arbitration arena. But in other courses, I haven't done everything. But anyway, that was just to say that I think this is also one of the processes that we'll see coming in the future, and that will help us as lawyers to be more tech savvy. And on the question, as you say, the low hanging fruit. I mean, obviously, this being here in a virtual setting is proof of it. Is basically the hearing setting being preferred, on having been preferred by practitioners, by arbitrators, as I mentioned before, because of this element, or as I quoted the judge before, because I want to see the witness, I want to feel him, I want to see if he's sweating, or if he's nervous, or if he can't talk well. This has been now all virtualized. I mean, I had a hearing last week. I was here in the office. The arbitrators were in the office. The witness was in Greece. Another witness was in Italy, and it worked out perfectly well. I mean, the technology is simple. We use Zoom, but you can use WebEx, you can use Microsoft Teams, you can use a whole range of other video conferencing systems. But virtual hearings, and it goes back to my point before, greener arbitration, also greener, less costly, and more time. So these virtual settings is fundamental. And obviously, perhaps also a step before, perhaps two steps before, and this is maybe, I'm sure Karima will know more about that, is having an e-filing platform. Instead of sending paper bundles, boxes, I've sent them, so I know what it is, and I feel bad about it. But yes, these huge boxes with all these, paper, having everything online on an e-platform, secure, and everything is exchanged there. That's another low-hanging fruit. It's I don't know, perhaps Karima can tell us more about it. I don't think it's that complicated, and it's easy and access for everybody. And that will be my last point, a step before is in the document review. Whenever we get a case and a client comes, and I had that in the case I just mentioned before, where the client came with a box of emails printed out. I mean, how am I? Obviously, I can go through it all. I can review it all with the time and the money and the effort that this costs. But if we and there exist platforms where you have all these emails filtered through a program. Relativity is one of these software that does this, and it just saves you time, saves time to money to the client, and you can have everything much more easily processed. But I'm sure Karima has other points on that.
Go ahead, Karima.
So I completely agree with Tomás. I think that an online depository of the case files is somewhat. It's something that every case should have. I don't think it's something that should be complicated. It's somewhere that the parties can store their files, that can access, that they can upload their briefs, their exhibits, and that can be easily accessible to everybody, but that can be also secure. This is something that I think is really important, and it's something that I think every arbitration center or provider should have. This is something we have since 2016, and for virtual hearings, I think that I think it will be interesting to see how they change after COVID. Will clients really want to pay for their lawyers to fly all over the world for hearings? Because the expenses of hearings are outrageous in some cases, depending on the size of the teams, the seat of the arbitration, how long the hearing is, and other factors. So it will be interesting to see how much and how many cases really do go on and return to in-person hearings, because I think that it's really in the user's benefit to have hearings that cost $0 in terms of fixed fees of hotels and air fees and all that, and I think it's really, really helpful. And like Tomás said, you're looking at the person. What's interesting, and I've read literature on this, is will we have more technology later that will get to have sort of like, since we're filming people virtually on screen in these hearings and at such a close range, will this in some way affect, or will we have people who can interpret whether they were lying, or body language, or other sorts of interpretations that we would otherwise not be able to do in an in-person hearing? So that takes us to other types of questions that would be interesting to answer, and I think that we do not have the answers to those questions right now. But I do think that especially in small cases where it doesn't make sense to spend a lot of money in hearings, these are really, really great tools.
Great, and we can go to other complexities. I won't do that on this discussion, but for instance, I imagine if you use certain type of technologies, the execution of the awards could be automated and many other things. I'm not gonna get in too deep, but I do foresee that, for instance, at least from my perspective, the low-hanging fruit has been more in evidence tools. So for instance, as Tomás says, a review tool for documents, or it could be e-evidence, or even the exchange of documents in a safe, let's say, environment that has cybersecurity measures. I think sometimes we disregard the importance of evidence and the cost associated to exchanging briefs, exchanging documents, sometimes discovery, if you're more in the US rather than in other, let's say, civil law systems. So there's a lot of expense going through evidence. So I would say that it, for me, or at least in my experience, is the low-hanging fruit. But there are many other items. For instance, if you are arbitral institution, you can create certain document automation platforms to automate certain documents that you might need for each case that normally are a templated version. The only thing that might change are the names of the parties, the name of the appointed arbitrators, and that is what it could be the procedural order number one. If I go back to some of the exercises, but again, just as a simple exercise. So with that, I want to start wrapping up this discussion, and I want to go to I would say, the core question that I want to hear from you both. And again, sometimes, and I could be very upfront, and I think that is part of this discussion. Sometimes we hear discussions about artificial intelligence, about how it's going to disrupt arbitration, how it's going to disrupt the legal industry, how the future robots are going to automate. And I'll always start with a premise, even though I'm in technology, we got to remind ourselves that the legal profession is going to remain human at its core. Technology can and help us and leverage our efforts. And that's why probably Tomás heard this on that specific podcast, that the true profession of a lawyer is to focus on the substantive issues, not necessarily on generating a form or filling out blank spaces on a document. It's actually analyzing the complex legal issues from a matter. It could be a corporate matter, it could be a litigation matter, it could be an arbitration matter, but that is going to help you even more, in the sense when you incorporate technologies, you can focus more on those aspects that really require the in-depth analysis from an attorney rather than just filling out forms. I remember when I started as a paralegal or junior entry level, I would say most of the time I was just filling forms that I was thinking on the back of my mind why we don't automate this type of things that are pretty easy. But I would like to hear from you. Are we in a moment right now in the legal industry in which we should consider complex technologies, again, artificial intelligence, smart contracts, blockchain, augmented reality, and other complex technologies, when we haven't even, let's say, scratched the surface in more mainstream or basic technologies? What would be your thoughts on that? And for that, I want to start with you, Karima, and then I want to go with you, Tomás.
Thank you, Mauricio. So I think we should, so the answer is, it depends. I definitely think we should keep looking for technology that helps us, that makes life easier, and that helps lawyers achieve whatever they're looking to achieve. So that helps with what you said, repetitive tasks, that and here I'm looking to whatever that case management, doc processing, all that. What I don't think is that we should leap and think that we're going to create a robot that's going to solve all our problems while we can't even have virtual hearings in all of the arbitrations, because it doesn't make sense to create something so complex while we don't even have something so simple. And also, and this is something that I addressed in the book that we in your book, but COVID has made us dive right into technology all the time, every day, and technology's all around us. And I'm not sure I want so much technology all the time, all around me. And so what I'm saying is, I love technology when it helps me, and I want it, like you both were saying, menial tasks that don't make sense for lawyers to spend their time with, tasks that make life better, that sounds great. But I don't think that we should put all our efforts into creating really complex tools that take more time in figuring them out, while we don't even have the time, the resources, or even the the trust in the tools that we have now from the general population.
And what about you, Tomás? What are your thoughts on this? Which I would say I completely agree with Karima's take, but I don't know if you have a controversial take on this one.
I don't know if you read my mind, but I do actually. I do have I have something I want to go. I want to say a bit the opposite what you said, and I'm sure you've read. And this comes from a book that I'm sure you've read, or a lot of you know about it. It's from Daniel Kahneman, Thinking Fast and Slow, and that really struck me when I read it. It took a long time for me to read it because it's heavy. But if I can quote it, it says, "Whenever we can replace human judgment by a formula, we should at least consider it." And why does he say that? Because he said that we as humans are inconsistent in making judgment because we're so dependent of our environment. Environment meaning our biases, the way we grow up, and etc. So in that way, I would challenge a bit what you both just mentioned, that the human element will stay, and obviously I think it's still going to say, but his book is so interesting in showing that us humans, us adjudicators, arbitrators, judges, lawyers, and this is also something that you mentioned in your article, Karima. We have these inherent issues or biases as human that trump sometimes what could be the just a judgment or the just decision. Having said that, of course, I'm here on a controversial basis. Having said that, and I've seen that in the practice, and I've seen that in the arbitration now, there is this human element that is inevitable, and just we can't take it out. And as what I mentioned at the beginning, these elements of fairness, of justice, of compassion, of empathy that are inherent to the dispute resolution system. With again this thing that, as we see, programs can provide us with a certain level of certainty. And then I'm talking about what I mentioned before, not in terms of giving a judgment, but what I mentioned before in terms of reviewing documents, such as the software relativity, but other analytical tools, and I don't know all of them, and I haven't went through them, all of them, but for example, a tool like Lex Machina, BrainSpace, Ross Intelligence, these kind of tools have really enhanced the way the legal profession has gone through. And this is obviously a bit more in the common law system, and perhaps not as applicable to arbitration because it needs data. And for the moment, one of the key premises of international arbitration is confidentiality, even though some institutions are making a step towards transparency, or at least publishing their arbitral decisions, always depending on the will of the parties. So I think there's, following what Karima said, that we have some basic tools, we need to master them, to have, as I said before, a ground leveling field for everybody, for the arbitrators, for the parties. And that makes me think from another hearing I had, where we suggested the arbitrator would take the lead on the virtual hearing, and it was quite reluctant to it. So showing the problem of mastering well the technology. So mastering the technology as we have now, but keeping a look and being proactive and being open for all these different tools in document reviewing, in presentation and presenting graphics. What else? Transferring data and just being on top of these tools, which will just enhance the way we work and focus. And this is going to be the last point on focus on what is important is the legal strategy, the legal discussion, the substantive issues of the case or of a client's case.
Go ahead, Karima.
Tomás, I think we agree.
Okay.
I think you were agreeing with me. What you mentioned is exactly what I mentioned in my chapter. I actually mentioned Kahneman, and yes, that is true. But the thing with that is that there, at this point where we are now, even even machines are not impartial. So so we have to work a bit more. So that's my point. So there's a long way to go still. So then you read about I don't know, Elon Musk wanting to put a chip in somebody's brain and doing I don't know what, and then you say like we don't have virtual hearings, and then that doesn't make sense. And so that's my point. Like, don't continue with the chip in the head while you don't have virtual hearings. That doesn't make any sense. But I completely agree with the thing that humans are not completely rational, and that we do get swayed by other factors. And it is interesting, and it would be interesting to have a more independent and impartial adjudicator adjudicate disputes. But I don't think at this point that would be the case because of everything that we've mentioned. But I think we're all on the same page.
I would say on this, I think I have a take with Tomás in the sense that I do agree with the premise on humans are not necessarily the best assessing different situations. And that's probably, I would say, one of the noble aspects of arbitration, that every case has its own caveats. Every case has its own set of facts that are going to probably be different from the first case on a similar matter that made you sway, let's say, the path A, but now because of different facts, of different communications, of different emails, and how the contract was drafted, you're swayed on way B. I completely agree with that. And I hope, and this is probably my futuristic approach, that we become more objective in our assessment, and that is what is something called lex cryptographica, which refers to the code is law, and that is on a book that is called the Blockchain in the Law, the rule of code, in the sense that we might be envisioning, and we are not there yet, but as things progress, we might be relying on some adjudication with pure code. Again, that doesn't mean that I want to instill fear in everyone that is hearing right now and saying you are going to lose your jobs or you're not going to be an attorney, because attorneys are going to still be important. 20, 30, 40 years from now, attorneys are going to still be important. The important thing is that you got to adjust and adapt to how the market is shifting and moving. And if you understand how to embrace certain technologies to leverage your practice, you can excel in now a moving industry. So with that, I want to start closing, let's say, this discussion, which I think has been wonderful. And I would ask a final question. And on this one, I would like to start with you, Karima. And is, if you could, let's say, put your futuristic hat, what is your take on the outlook of the relationship between technology and arbitration? Are we going to embrace it even more, even after COVID? Do you think things are going to dial down for a bit? Do you think there's going to be a trend of going back to normal and then reassessing operating technology? What is your take on now the future outlook as we foresee the end of the pandemic and the beginning of a new chapter in world history, I guess?
Thank you. Okay, so we're reading the future, and I do think that we are going to embrace technology more, just because it's a necessity. These types of events are going to keep happening in some way or another. And so technology, like we see it now, or like we're using now, is definitely going to become more important. But also technology, like the way that we were speaking before, in the sense that helping practitioners and arbitrators to become more efficient at their jobs, just because the market and the users are going to ask for more efficient use of their time, for more economic rates, for shorter cases. Arbitration is just another service, and we have to adapt to changing times, and that's something that we have to be mindful of. And so technology, I think, is something that we need to embrace to be able to offer a better service. And so if we have all these people like you who are interested in this and who are coming up with great solutions for practitioners and for everybody who's involved in arbitration, then I think that slowly but surely the arbitration community will be adapting some of these changes, and will definitely use it to its advantage.
And what about you, Tomás? Do you have another controversial take with us, or do you want to take this one?
No, I think this is kind of a more common sense approach. I don't have an Elon Musk futuristic thought about the what's going to happen next. But I think coming back to what we've said throughout this past hour is this has been a push for everybody in the industry of international arbitration, and I hope and I think it is going to be the case that we're going to maintain this push in terms of having less costs, having more virtual hearings, meeting clients, not necessarily going and seeing them to prepare hearings and prepare witnesses, but doing them online. Being more thoughtful, as I said, about obviously climate change and having these arbitrations more green, and we actually see that with the change of arbitration institutions. The ICC had modified its rules in 2017, and with the pandemic and obviously was some other issues, it changed them in this year in 2021, because there was some obviously ambiguity if hearings could be held virtually or physical. One example. So we're seeing that we've had to, in a way, catch up, and we have to set the scene for what's gonna come later. And in that sense also, and perhaps that also goes back to what I mentioned before in terms of academia, we're going to see more aspects in terms of training, or perhaps I hope to be more tech savvy, to know more of the tools, or that will become more mainstream in dispute resolution, in the dispute resolution setting. So yes, we have a basis now. We've made some progress, and I think this progress is going to go forward and keep going on.
And with that, I would probably would make a call to action to the arbitration industry. Although again, I'm not a practitioner anymore. I used to be one. But let's not think that because COVID ends, we should stop innovating, implementing technologies, and embracing technologies. Again, there's a lot of potential for the arbitration industry if we understand how to incorporate technologies in facets of the process. It doesn't mean that you have to transition from a full digital process to an ODR platform and forget about some of the human or physical elements for an arbitration. But let's not think that because of the pandemic ended, we should stop innovating, we should stop pushing efficiency, and we should stop using technology to improve the legal industry in general. And I would say that goes to a deeper thought in my mind, that is access to justice. As we had a topic with Tomás, there are over 5 billion people that don't have access to justice. So in order to expand that human right to other industries and to more people, we have to make improvements and create other alternatives that can benefit from technology. And with that, I want to wrap up just with a probably a brief topic, and is, as Karima and Tomás mentioned, there will be a book that will be launched in the next couple of weeks. That is a compilation of over 45 articles on arbitration and technology in both English and Spanish. I had the pleasure to have Tomás and Karima and many other practitioners around the world that wrote an article. And in fact, we have one of the, I would say, most meaningful contributions is from Colin Rule, that is regarded as the, let's say, the granddad of ODR. He implemented the ODR system for eBay. He has been one of the pioneers in ODR systems. But for instance, he wrote the prologue for the book. But again, this is a book that is a bit different. In fact, it started last year, even before the pandemic. Just the pandemic accelerated things, I guess, with technology and arbitration. But this is an invitation that we're going to keep you posted and updated once the book is launched, but it should be in the next couple of weeks. But with that, Tomás and Karima, I don't know if you want to give a sneak peek or a small preview on what your article is about. I know, Tomás, yours is a contribution with 2 authors in English, and yours, Karima, is a contribution in Spanish. So if you can give a sneak peek in 30 seconds, that'll be great. So maybe we can start with you, Karima, and then we can go to Tomás.
Sure. Mine is about robot arbitrators and whether we will have them. So it's about artificial intelligence and whether we will be replaced as arbitrators. And it does an analysis about whether the existing tools will actually replace arbitrators or help arbitrators. And a lot of the questions that we address today are addressed in the book. And as you can see, I'm still a bit wary about where we're going with this question. But if you read the article, you'll know more about it.
Okay, Tomás, do you want to give us a sneak peek as well?
Yes, I think it was a great initiative from you and Joel to put this in place, and a great topic, obviously, because of technology. My article with Leo Jedwab, a colleague of mine here, was centered more on the automation of decisions. So the way some computers, some algorithms can generate a decision automatically on the basis of input of data from opposing parties. And it goes through the pros and cons of this process, whether it is feasible, whether we can see that coming in the future. But it sometimes on some aspects, obviously, it follows what follows Karima's article, even though we have a different paradigm. But it's really this thing of also this question of access to justice, whether we can have these processes automated, especially the adjudication, which is quite to the point in this era.
Great. And on this one, I'm going to cheat in the sense that I'm not going to give a sneak peek or a preview of my contribution. So I do invite you to buy the book. It's going to be launched in the next couple of weeks. And I'll make sure to give Laura and the Arbitration channel access to the book so they can share it with all the audience and all the followers of the channel. So with that, I want to start wrapping up this discussion and just make a final consideration. And I want to see if Tomás and Karima have final considerations, but at least from my perspective. And again, I'm coming from an ex-practitioner now on the technology industry, and I'll focus on more providing technology solutions. But I do understand the pain points of both worlds. I understand the struggles of both worlds. And I would say more now on the technology side, we cannot expect that arbitration is going to change and embrace technologies if the technology industry is not making its part of the deal. And when I say it's part of the deal, is that we got to become more human-centered in the approach of developing technology and technology solutions. And for that, we need to understand that true and meaningful tools and technologies that can impact a certain aspect of the legal industry means going to the stakeholders, ask them questions. What are their concerns? What are their struggles? How can we improve a specific tool? Because again, if you just throw a tool without necessarily relating yourself to the struggles or the pain points, you're just gonna waste money, waste time, and you're gonna shy away from technology. So I would say there is a lot of efforts that need to go into bridging technology and arbitration. But again, that is not only from attorneys. It's going to require UX, UI designers, graphic designers, software developers. So I'm looking at a more collaborative, professional approach for technology. So in my perspective, again, even though I'm a lawyer, I don't expect my role in my job to be automated in the next 30 years. I focus more on startups and venture capital nowadays, but still, there's a lot of components that you gotta envision that even though as an attorney, you still have a substantive set of skills that have value for your client. Again, don't be afraid of embracing automation tools or case management tools, because that is just going to leverage your skills. That is going to give you more additional skills under your belt, and that is going to provide you to other outlooks of the industry. So with that, Tomás and Karima, I want to ask if you have final thoughts based on this discussion, and any call to action that you might have for the audience that is hearing this talk today. Tomás, do you have any final thoughts on this?
Not really. I mean, what you said, it goes right to the point. I mean, our profession as practitioners, and coming from the practitioner side, is really, we have a set of analytical skills, capacity to analyze, to think, to obviously know the law. But what will also make the difference in your work, and I see that when I write briefs, when I have to look at documents, when I have to prepare a hearing, is being tech savvy in some programs which will enhance the way I work. So obviously the basis is going to be there, but we have to be more proactive in understanding and taking the time to use properly the tools that are available to us.
Karima, do you have any final thoughts?
Sure, and just from the perspective of an arbitration center, we try and implement whatever is at our disposal and what we think will be more helpful to our users. But I also think it's important for the users to come up to the arbitration centers and say, hey, this works better, this doesn't work. I think we should use this. This is a learning process of all the actors involved, and I think there should be a dialogue in place from everybody. And I think that's what's going to make everything work better and smoother. So I think that would be a good thing.
Great. So I want to thank you both, Karim and Tomás. I noticed that there's one final question. So if someone wants to tackle it, I know we have 2 minutes. So Clarissa Fernandez is asking, have you ever had issues with witness deposition in an online hearing? And do you see this as a problem? I don't know, Tomás or Karima, if you ever had any issues with this, or if someone wants to tackle this question.
I'll go. I'm not sure what is meant with witness deposition. I'll say from the arbitration, I guess, witness hearing and cross-examination and cross-examination. The last hearing I had, I mean, as I said, the different witnesses were one in Italy, one in Greece. The cross-examination went fluid because the connection was fluid. Obviously, that could be a risk, sort of guerrilla tactic to say that the connection doesn't work and etc. We also had a case even with an interpreter, and that was also online, and that went well. So to be honest, as long as the basic tools, the hardware works well, the camera, the audio, the microphone, it went really well. And we had a big screen, and we could see the witness very well, uncomfortable in some cases or more comfortable. and so my experience is positive.
Karima, any thoughts on this so we can wrap up this discussion?
I've had generally good experiences. So as Tomás said, in general, if the connection is good and the witnesses are well behaved, thankfully, I don't want to jinx it.
Great. So with that, we come to an end of this discussion right on time, 1 hour and 30 minutes. So again, I want to thank all of you for being in the audience today, for your questions, for tuning in from Brazil, from Turkey, from Texas, and from all over the world. So with that, I want to thank again Lauro and the Arbitration channel for the invitation. And again, a call to action to keep embracing technology. So back to you, Laura.
Okay. So no, I just want to thank you all, Mauricio, Tomás, and Karima. And we're gonna back to this discussion another times. So I probably will invite you again. So we have too much subject to cover in the next webinars and things like that. So nice to see you. Keep safe. Bye bye. Have a nice day for all. See you.
Thank you. Bye-bye.
Thank you.